All right, folks, thanks so much for joining us. We're here I'm Judd Campbell. I'm a visiting professor here at NYU this semester. And we're here for the Latham and Watkins Forum on defamation lawfare, reputation, retribution, and press freedom. We're going to be recorded here, so if at the end of the conversation, sometime around just a little after 2 o'clock, if you guys want to start to come up and ask questions, please do so at the microphones. I'll just start by briefly introducing the panelists. We have Megan Meier, who is a founding partner at Meier, Watkins, Phillips, and Pusch. She mostly does plaintiff side work, including the 2020 election defamation case against Fox. Next up, we have Elissa Cohen, who's a vice president and assistant general counsel at Vox Media, followed by our own Burt Neuborne, the Norman Dorsen Professor of Civil Liberties Emeritus here at NYU. He's a founding legal director of the Brennan Center for Justice, and among many other things was a former national legal director of the ACLU. And then last but not least, David E. McCraw, who's the senior vice president and deputy general counsel at the New York Times Company. So we're here to talk about where we are today in terms of defamation law, in terms of protecting reputation, while also thinking about questions of press freedom and civic discourse. And I wanted to kick things off by just getting a sense of what the lay of the land is. So how is it that our current environment is changing? What does the state of play look like? What sort of defamation cases are we seeing now that maybe are different than what we've seen before? And so just kick it off. For those of you who are on the ground, how is it that the current environment differs from what we've seen before? What characterizes the state of play right now?
Everybody's looking this way, so it must mean I'm supposed to start. The New York Times was sued recently by a golf club owner named Donald Trump, and that has gotten a lot of publicity. I do think it's a little misleading because we haven't really seen a shift. We may, but we haven't really seen a shift in the kind of cases that are brought or in the volume. Defamation cases are rarely brought. At least that's our experience at the New York Times. We may get 4 defamation cases a year, sometimes 2, but it's around that number. We just haven't seen that sort of use of defamation to be used against news organizations that we see in other countries. I was doing a pro bono project in Montenegro a few years ago, and I sat down with the editor of an independent newspaper, and he said, well, what's your libel docket look like? And I ticked off 2 or 3 cases. That was about it. And I said, how about you? And he pulls out a spreadsheet, which has 27 or so cases on it, and that every month somebody in power in Montenegro was suing. It was really the weaponization of libel, which was, of course, one of the things that led to Times versus Sullivan in 1964. So we are not really that focused on defamation as a threat to press freedom. We see a lot of other stuff going on that worries us more. But as I said, these things can change, and we certainly saw in the first Trump administration a ramp up of politically motivated defamation cases towards the end of the first term.
Yeah, I mean, oh, sorry.
Go ahead, no.
I was just going to jump in and sort of give you guys a little bit of the lay of the land because we are addressing a group of law students here. I just wanted to level set and sort of tell you what our jobs are. What do we do? Because I know that when I was in law school, I didn't even know that the job that I do was a thing you could do with a law degree. So what do media lawyers do, at least in-house on the publishing side, and like what does our day-to-day look like? And I think that's going to inform a little bit of like how the landscape has changed. And so the thing that I do when I'm doing this part of my job, and my job obviously looks different than David's job and looks different than other people who do my job. The way we work with journalists and the way we interact with defamation law is really at a sort of check level, right? Reporters are out in the world and they are curious about things. There are newsworthy things happening. They're investigating. They have questions they want answered. They're out in the world and they're gathering all of that information. And then the next step in that process is they want to share all of the things that they've learned. They want to write about it. They want to share. They think that they have some, there is a public interest, right, behind these, this story that they want to tell. Now, that's not true. Of course, sometimes it's just entertainment, it's information. There's all different stripes of what that looks like. But it's our job as media lawyers in-house to work with our journalists and to work with our editors and check them and say, not that we are fact-checking their work, that's their responsibility, but we're checking that they have done their homework, right? And we're making sure that if and when somebody does unfortunately come and sue us, and I often tell our reporters, I don't have a crystal ball, I can't predict when someone is going to sue us, but what I can help them do, right, and this is really on a very granular level, is to make sure that if and when somebody does come at us, that we have a sound, solid legal defense, and that's under the construct of our defamation laws, to make sure that we can protect the work, the hard work that they've done. And of course, a lot of people who do our job, right, feel pretty passionate about the mission of journalism and making the world a better place and shining a light on corruption and all of the things that you imagine when you're thinking about the sort of ideals of journalism. So that's just sort of to kind of level set of like what we do on the day-to-day. Now, I think my answer for how things have changed and how the landscape has changed is probably going to differ, because of the size of and how long I've practiced this particular area of law. I would say that there hasn't necessarily been a shift in the legal landscape per se of the laws, but I would say there's a shift in perception and pressure exerted on journalists in different ways that has made our jobs really challenging and has made the jobs of journalists really challenging. A lot of that comes out of the political discourse, that you're hearing day to day, attacks on journalists, those kinds of things. But what that looks like in practice on a day-to-day for an in-house media lawyer is not necessarily litigation. It is sort of all the little other touch points that you're doing throughout the reporting that make it more difficult. So those little steps along the way, I think have become more challenging. And, working to combat the sort of narrative that everyone, everything is fake news, has become a real challenge, I would say, just in the world.
So my sense is and you guys ought to know, I was in law school when Times v. Sullivan was decided. The rumors that I was in law school when the First Amendment was written are not true. Those are not true. But I was in law school when Times v. Sullivan was decided. And the landscape has changed, I think, quite dramatically. The number of libel suits and defamation suits may not be up per client, but they seem to be up across the board against large numbers of clients. For example, I don't think it's a coincidence that significant libel and defamation cases have been filed against ABC, CBS, the New York Times, and the Wall Street Journal, all in a relatively short period of time. And I think it reflects something that transcends the libel and defamation area, and that is the politicization of the courts. The understanding among powerful entities in the country that courts that were once viewed as a place where you would seek redress for your legal rights, and it would be a kind of closed world in which you went in and fought for legal rights. It's now just another piece of the political spectrum in which the filing of a lawsuit is not just an effort to get redress legally, but it is an expression of political will. It's an effort to speak. And some of these lawsuits are filed without regard as to whether they're going to win or not. It's the filing of the lawsuit that matters. The news value of the litigation, the fact that it reinforces the assertion by the speaker that by the alleged target that he's been or she's been poorly treated, and so that it's more of a political strategy than it is a legal strategy. And I don't know how to back away from that. I think it's terribly dangerous, but I don't know how to back away from it, especially when we add the last piece of the puzzle, and this is something that's very troubling to me, the idea of collusive settlements. The idea that these actions lend themselves to being settled for reasons utterly unconnected to the merits of the lawsuit. They become a mechanism for the channeling and funneling of disguised bribes that couldn't be made openly because there would be no justification for the payment, but which can be made as an alleged settlement of an alleged lawsuit. I think Paramount, when it settled the CBS case, paid $16 million so it wouldn't have any problems with antitrust when it wanted to merge with Skydance. And I think Disney, when it settled the ABC case for $16 million, was worried about buying its way back into the good graces of the administration after having had the effrontery to stand up for their gay employees in Florida. So the possibility that these lawsuits are really not about law, but they're about something else, is for me a new phenomenon that has to be dealt with.
So I'm curious about, outside of the context of filed lawsuits, how does the law influence what's happening for your reporters? So takedown requests or threats of litigation. Do those sort of things come up in the day-to-day practice that you all see on the ground? Are there other types of litigation that you're worried about besides defamation? What are we missing here besides just the sort of front page story about lawsuit filed against New York Times Company or whatnot?
I say, well, David wrote a whole book about it, so you
I look forward to getting one of Megan's letters, representing plaintiffs, and we sometimes disagree, sometimes we see eye to eye. There has always been, and I think Elissa would confirm this, a huge difference between the number of letters you receive threatening lawsuits and the lawsuits you actually get. So the practice of getting letters, responding to letters, is really part and parcel of the job of the in-house counsel. Because, and I wholeheartedly agree with everything Burt has said about some of these big settlements that you've seen with ABC and with Paramount and CBS, but that there is, I think, a move to try to look for other causes of action other than libel, because if you look at that body of case law that was generated by the Supreme Court between 1964 with Times versus Sullivan and over the next 25 years, which is an incredible expansion of the First Amendment as a protector of a free press, that libel, I think, frustrates some people who are unhappy with us, and so they look for other means, other ways of bringing these claims. In our case, Donald Trump first sued us in 2021 for tortious interference, claiming that when our reporters approached his niece and she provided documents to our reporters, and those documents happened to be subject to an NDA within the family because of a dispute over an estate, that was tortious interference. That did not challenge the story, which dealt with his finances and his taxes, did not challenge the truthfulness of that, but instead made this claim of tortious interference. We have seen in this year someone bring a suit unhappy with our coverage of Israel and Gaza, claiming consumer fraud, that it induced the subscribers in New Jersey to subscribe to the New York Times based on deceptive information. Obviously, a very political type suit, one that we think is preposterous, but again, looking to bring claims without resorting to libel. I think probably, and I alluded to this earlier, one of the really concerning things, though, is the use of the Federal Communications Commission to try to intimidate the press and to govern content. That has never been part of the FCC playbook. It's not how they operated. They have gone out of their way for the entire time they've been in existence to avoid getting entangled in content decisions, with some very rare exceptions, usually for material they found was indecent. But now you see them using that power, and that concerns me when you have a government actually using governmental power.
Can I respond too?
Great.
So, as I was introduced, I'm on the plaintiff side of this. So I have clients coming to me saying, hey, XYZ media outlet wants to write this story about our company. It's no good. We don't want them to write this story. What do we do? So there's a big assessment that happens there in terms of what we can do under the legal framework that we have. So here's something that's kind of interesting that you might not have thought about. English is spoken all over the world. And when something gets posted online, it is published all over the world. And so when I'm dealing with clients from wherever, we're not always only looking at US law, right? We're looking at what are the options globally, and do I need to connect you with my friend Amber, who practices here in New York and also in the UK? Or do I need to connect you with my friend who's an Irish libel lawyer or a German libel lawyer? So our laws in the United States on the spectrum of super protective of the press, the free press and free speech, to super protective of reputation and being able to put journalists in jail. We are to the far end of the protection of the free press in the United States. And then after us, I would say it's like England, UK, Germany, Asia, the Middle East are kind of to the further end over here, right? So that's where we have decided as Americans to draw the line, is to be more in favor of free speech and the free press. And what does that mean? We were talking about this earlier. The First Amendment, Times v. Sullivan, a lot of protections have been developed over the years that make it very, very hard to win a defamation case in the United States. If someone has misrepresented you, you not only need to show, you need to prove that what they said was false, that what the outlet published about you is false. But as a general matter, you have to show that the reporter, usually, you're going to have to show that they knew or recklessly disregarded that what they published about you was false. So when I have clients come to me and say, I don't want the New York Times to write this, it's nasty, it's blah, 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 I have to say, okay, is it false? Right, that's question one. Can we prove it's false, right? And so if the answer is not, yes, it's false, I'm like, okay, then talk to a PR person. Let me connect you with them, right? I'm not your guy if what is being reported about you is not false. So I need to know, okay, is it false? All right, can we prove it's false? And then I say, what's the next question? Have you told the reporter it's false? Have we provided the reporter with information showing that it's false, right? And a lot of clients don't like that. I shouldn't have to tell them anything. I shouldn't have to respond. But I actually think it's not the worst system in the world because I do think it incentivizes a bit of transparency, right? It incentivizes openness. It incentivizes, folks to respond to the press if they want the record to be accurate and fairly reflect what's going on in their business or in their life. You've got an opportunity to respond. So we are extremely protective here in the United States of the free press. And so I view, my role as a plaintiff side libel lawyer to help clients navigate that sort of pre-publication world in trying to have the reporting be fairer and more accurate. And then if that fails, bringing a defamation claim as a last resort. Yeah.
I mean, I love hearing you say that, right? But it's also, I think, Times v. Sullivan it's one of those things, and I was thinking about this when I was coming here, is that it's a framework that, protects the press, but it also, it tells us, it guides us as media of what to do and what not to do during the reporting process. And, it forces us to have those conversations with our newsrooms, have you assessed the credibility of the sources and the information, right? And because I know, depending on the story, I'm going to get that letter from Megan that's going to say, we have this particular information. And so the reporters rightly should view it as part of their job to really look at the landscape of all of the information. Now, of course, they're entitled to, formulate a conclusion based on everything that maybe your client will or won't like, but it is a system of checks that really forces you to have that conversation with your newsroom to say, what do we know? What do we have? And that's often really the conversations I have with our reporters and editors is like, it's okay, how many sources do we have? Are they credible? What work have you done? Is there anything else, right? Or is what, Megan's client is saying, right, is that right? Did you think about that? Why or why not? So I do think that it's a really healthy framework, in that way. And, to my mind, it works. So that's really the takeaway. And I don't mind getting a letter from Megan most of the time, because it is a healthy exercise, right? I mean, that's sort of, if we're really honest about the mission of journalism, we should want to get it right.
We share the same goal, right? Is like, I don't want to bring a defamation suit. I want the story to be accurate. And Elissa doesn't want to get a defamation suit for, we want the story to be accurate, right? That's what the goal is. And we may have different perspectives on it, but there is a little bit, there can be some back and forth there.
So I wonder if I can bring in the professor here. What is New York Times versus Sullivan, and why did that whole line of cases get started?
Well, that really speaks to my being in school when it was decided. New York Times came out of a very, very specific context. It came out of the fact that the Times was one of the only national papers. There were a few national papers, but very few, that were providing significant coverage to the civil rights movement in the South. There were a series of Times reporters. I was down there, and so you looked around and you wanted to see who was covering. And there was always a Times reporter, and they were providing absolutely crucial windows into a world that the rest of the country didn't understand. The civil rights movement was essentially regional. It was essentially a movement to try to get a quarter of the country to adopt the values that the rest of the country had long since adopted in terms of racial equality. Now, whether they were living up to those values is a different story. But in formal adoption of the values, 3/4 of the country had done one thing, the South had not. And the civil rights movement was essentially, in its inception and in its most powerful iterations, was an effort to get the South in line with the rest of the country in terms of accepting. And having news coverage to the rest of the country was utterly crucial to the success of the movement. If all you had was local coverage, or occasional coverage by the electronic media, by the emerging electronic media, you could never have built the political pressure needed to make the civil rights movement succeed. So keeping national press coverage alive was one of the crucial strategies of the movement. And not surprisingly, the Southern defendants realized that if they could choke off that coverage, they could choke off the rising political pressure to force their localities to adopt values that were new values. And the way to do it was to use the libel laws. No matter how good a reporter is, and no matter how hard the reporter works, there will be occasional mistakes because of the time pressure, because you don't have the ability to sit back and catch everything. So there'll be a small question of whether you got it exactly right. And the Southern opponents of the civil rights movement jumped on that. And they grabbed all those articles and they combed them for minor discrepancies that could then be the basis of a libel action that would be tried to a Southern jury. And the Southern jury was asked to repel the invasion of Northern outsiders. who were coming in to try to change their world. And the Times was facing a series of very large damage awards for relatively small mistakes made in the coverage of the civil rights movement. I think I was not privy to any of the internal discussion in the Times, but the rumors were that there was going to be some point where they were going to have to pull back. That economically it was going to be so ruinous to have to deal with these repeated million-dollar verdicts and this was back in '63, reputed million-dollar verdicts for trivial mistakes that they'd have to pull out. And so my sense is that Times v. Sullivan is another case that falls within what I call the gravitational pull of race on the Warren Court. Race was the dominant thing they thought about in everything. Statutory construction, separation of powers, First Amendment, religious, and any issue that crossed their desk. The first thing they wanted to know was how it was going to affect the racial climate in the country. Because this was the years after Brown. It was the years when we were attempting to carry out the hope of the Brown decision. And Times v. Sullivan was an effort to insulate the Times and the other national press from this kind of hostile takeover. And it worked. For its time, it was a brilliant tactical success. Now, whether it was the right way to deal with libel is a different story, but it was politically an absolutely brilliant counterstroke by the Supreme Court.
And most of the doctrinal confines are worked out by the mid-'70s. That's 50 years ago. It would be kind of odd if the balance that they struck 50 years ago were still well-suited to the environment we're in now. Is that the case, or?
Well, the doctrinal stuff, you guys know it probably better than I do because you live it every day. But my sense is that the doctrinal stuff hasn't changed much in the 50 years. By 1975, 1980, all of the jots and tittles and commas had all been worked out, and you could write a really good hornbook of the law of libel. And I think that hornbook would still be basically useful today. For someone. So I guess, and that says two things. Maybe it's right, and maybe the institutional players with a stake in retaining it, the very strong press, maybe they're very powerful, and it's tough to change it in the teeth of their opposition. But for whatever reason, the solution that the court worked out in Times v. Sullivan is the current solution. And I would love, if we had a chance, to talk a little bit about alternatives. Is it the only solution? Is it the best solution? But it is a solution that's worked pretty well for a long time.
Yeah, and I would just underscore what Burt was saying about the way libel suits were being weaponized in the South by white, racist, powerful people. L.B. Sullivan was the commissioner of the police and some other departments in Montgomery, Alabama. And he sued over an ad that was signed by supporters of Martin Luther King protesting the way things were happening in Montgomery. And if you think about this from a libel standpoint, libel is supposed to be about protecting a reputation. I can assure you that first, there were fewer than 40 copies of the New York Times that circulated in Alabama that day. That the idea that somebody of one of L.B. Sullivan's racist friends thought less of him as a result of an ad in the New York Times is really quite extraordinary, right? But he did find 6 good people to step up and say they saw that ad in the Times and they looked at him and they thought, oh man, that guy's a racist? That's terrible. And he gets $500,000 as his damages. And so that was exactly what the Supreme Court was trying to put the brakes on. I think what Professor Campbell is getting at and is asking is, well, that was a time when these suits were being brought against institutionalized media that had editors and had standards and had professional judgment that they rendered. And that institutional organization, that institutional value set, meant that you could trust them. And if you read many of those decisions after Times v. Sullivan, it's really based on the idea that they are going to let news organizations decide, rather than have courts decide, about about how reporting should be done, what's adequate, what's not, and in large part to make those decisions. Does that still work in a digital era? Let me just put too fine a point on that, which is that this goes to something Elissa said. You know, the standard from Times versus Sullivan is subjective. It asks the question, did you, the publisher, did you, the reporter, did you, the editor, know something was false and publish it anyway, or did you entertain substantial doubt? That's not very useful in pre-publication review. If somebody comes to me and says, I want to do a story that says Hillary Clinton was a Soviet asset or was a Russian asset, and I said, do you believe that? And they say, I sure do. I don't say, that's great, let's go with it, right? We ask the questions that Elissa asked. How do you know? And that's really driven more by institutional values and norms. And Times versus Sullivan can be misused in a digital age. You get to results that are hard to explain. Courtney Love, the rock singer, widow of Kurt Cobain, goes on Twitter and says a lawyer took a bribe and betrayed her. She gets on this, she gets sued for libel, she gets on the stand. Had she done any research? No. Did she have any basis for that? She just thought it. She wins. Because she had, in her mind, subjectively, she thought it was true. And I think that's part of the tension here, is it worked really well when we were talking about institutional media. I think we have to ask some questions about, does it work when we're living in a world of X?
Yeah, I mean, I think what strikes me is the more things change, the more they stay the same. So, you know, in hearing you sort of describe the atmosphere surrounding, you know, the timing of Times v. Sullivan and, you know, all the concerns, I think we're sort of living through that again in a slightly different version of it, right? I think that it is being, you know, the libel laws and other laws, right, I would say, you know, we've also faced pretextual claims in copyright, right, as a means for people who want to get their story taken down. They say, oh, you didn't have the right, you know, it's being used again, I would say, as a tool to stifle voices and to, you know, harass reporters and to make it difficult and expensive and, you know, too expensive to really publish. And, you know, I think what we're facing as a business, you know, I shouldn't say we, you know, everything that I say is, you know, this is my word, not Vox Media's word. I would say what we're facing as an industry is really a lot of pressure on deep investigative reporting, which is expensive, right, and is time consuming. And the smaller your outlet is, not everyone has, you know, Wordle, where they can fund, you know, different, you know, litigation and all of these things, right? Or has, you know, more lawyers, right? It becomes really difficult to, you know, from a pre-pub to post-pub to pre-litigation to hopefully no litigation, it's extraordinarily time-consuming and difficult. And I think over time, the difficulty is that reporters internalize that, right? I find that I'm getting a lot more questions about things, and which I don't discourage, you know, reporters and editors from coming to me with these questions, but we get a lot of questions about, well, I'm just reporting about this person, and they've heard somewhere in their mind, or they've read somewhere that this person has made comments, they've attacked the press, they've attacked the media. Can I not write about them? And you know, I'm constantly hand-holding saying, no, like, we are reporting, you should still be, you know, doing your day-to-day job, doing these things, like, let me be a little bit on the front lines of, you know, some of this. But of course, I'm one person, right? And this is, you know, magnified. If you go down the line to local outlets, they can't handle the heat of the sort of letter writing back and forth, the pressure, you know, all of the things that you have to show, you know, those subjective, you know, issues that come up in Times v. Sullivan. So, you know, I think on the plaintiff side, knowing that this is an exercise that you have to put folks through, right, to get this to press, that's really where the pressure is. That's the letter writing back and forth. And again, you know, while I don't mind getting a letter from Megan, who I know is speaking about the law, and we can have a real debate, within the construct of that law. I think what's also happening is that there are folks who are sending letters who are just wrong on the law, on the face of their letter, right? It's just sort of grievance writing, but you still have to spend the time and the effort to go through the exercise, right? Because again, Times v. Sullivan is this standard where you have to show, what did you know at the time? So, I think that has really been leveraged, and I think that's something that, again, the more things change, the more they stay the same. It's, again, a pressure that's being exerted. And, for smaller companies as well, they're just not going to be doing that kind of reporting, I think, over time, which is scary and upsetting, but, that's how it is.
So I'd like to get back to Burt's question about maybe what comes next or how things might be different. But before we get there, let's just put on the table another bucket of legal doctrines. New York Times versus Sullivan is a First Amendment case, and as Burt was suggesting, one of the goals of the justices was to, in some sense, provide a national framework for evaluating some of these questions. But another way that our law has recognized limitations on defamation suits and the overuse of defamation as an abusive form of speech suppression is through anti-SLAPP statutes. And so I'm curious if you guys can speak, maybe the first to speak can give a basic sense of what they are, but also does the state variety in anti-SLAPP create problems for you? Does it create incentives for plaintiff side decisions about where to file? Does it create incentives for reporters about what they think about when they have to make decisions about, or editors, whether they're going to pull the plug on an article based on what the legal environment in a particular state might look like?
Well, the SLAPP suit movement was, in some sense, the reverse side of the coin of Times v. Sullivan, because it used essentially very much the same kind of thinking. The thinking was that if somebody brings a libel action or a defamation action, not because they think they have a really serious legal claim that they think that they can win in court, but because they want to exploit the vulnerabilities of usually small speakers, sometimes non-institutional press speakers. Many of the suits arose out of the environmental movement, where environmentalists made allegations about companies, and then the companies tried to silence the allegations by suing them for libel and defamation. And so the effort was to create, they thought, a level playing field by saying, hey, if you file something about someone and you know it's not true, or you're guilty of reckless disregard about whether it's true, you're going to have to pay damages. On the other hand, if somebody whose reputation has been hurt by what you say sues you for libel, and they know, or should know, that they don't have any chance to win because it's not a serious lawsuit. It's just an attempt to slap the speaker with significant financial penalties for having dared utter the speech. Now, if you're in that situation, the speaker should be able to collect damages from you. Usually in the form of attorney's fees, but often in some states actually in the form of actual grants of damages. And so it set up a counterclaim. It set up a system of libel counterclaims where a particularly egregious libel suit could be met with a SLAPP counterclaim saying, you're going to pay my attorney's fees and you're going to pay me damages for having dared bring this. I can't speak to whether it's been a success, because I haven't been really involved in many SLAPP suits. My sense is that it worked initially. The environmental movement felt much better once they had the SLAPP suits. But I don't know whether it's a sort of general solution.
So as somebody who's assessing where and whether to bring claims, so how many states have them now? 37?
37
So 37 states have some version of their own anti-SLAPP statute. They're all a little different, of course, because yay, federalism. But some of them have mandatory fee shifting, some have optional fee shifting, some have interlocutory appeals. I mean, they're all a little different, right? But the general idea is what was just explained. So from my perspective, having potential clients come in, evaluating whether they have a claim, where they have a claim, and whether to bring one. All things being equal, I would prefer not to bring a case in a SLAP jurisdiction, primarily because of the extra delay. So I don't bring a case unless I think I can win, because I don't like losing. So I feel like I'm only gonna bring this case if I think I can win it. But if I bring it in Texas, right, and they bring an anti-SLAP motion, and I beat it, then they get to immediately do an interlocutory appeal, and now we're waiting around for 2 years. So as a plaintiff, that's extra delay, it's extra money, yada, 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 right? It marginally increases the risk, right? Because some cases are a closer call, so maybe you lose, and then you have to pay the other side's fees. What I will tell you, though, I don't think that the statutes have had the impact that folks think they have. So from my perspective, clients with a lot of means who have a decent case are not deterred by the risk, of having to potentially pay the other side's fees. What it effectively means is that for ordinary people who have been misrepresented, they are probably not able to bring a claim, right? So it essentially means that the ability to bring a lawsuit when you've been falsely represented is a luxury of the very wealthy, right, and of companies. That's my perspective on it.
Yeah, I think that everything that's been said so far on this is right, which is that it was very effective when big companies and land developers were suing environmental activists for objecting to the development or the mine or whatever it was, and they would win their suit and then get their legal fees paid by the oil company or the mining company or the land developer, and to try to and the hope was that would stop big companies from doing this because they would have to pay legal fees. I'm not sure it's worked out quite that neatly. I find the judges are skeptical, that they think, without articulating this, but I intuit this, that there's all this protection for the press. Why do they get one more? You have Times versus Sullivan. You win your case, take your victory, and go home. And that they're not that happy of the idea, especially in cases like Megan's talking about, where it is an individual versus a big institutional media company, that this individual is supposed to brings a suit, gets it dismissed, but is now supposed to pay the big institutional companies, big institutional media companies' fees. Many times the plaintiffs are without means anyway, that they brought this case, defendant wins, the publisher wins. Bringing an anti-SLAP to get nothing is usually not a very satisfying, to seek fees from that plaintiff is not very satisfying. And I'm not really sure Megan would have a better sense of this, is sort of the thinking that goes into it. Do people who want to sue start thinking about, well, what's the risk that I'll lose and then I'll have to pay the publisher's fees? I think most people are kind of motivated by the sense, I'm right, they're wrong, and I need my day in court, and not really thinking about what might happen down the line when there would, if they were to lose and may have to pay fees.
I mean, I think for us, it's just another tool in the toolkit in terms of, when you have faced down a truly vexatious litigant, right? Because this is a real problem. So first of all, for all of you, I would highly recommend, John Oliver did a great breakdown of anti-SLAP law. So if you can find it on YouTube, highly recommend, and it's a really great and humorous explanation of an area that I care a lot about. But I think it's a great tool in the sense that when you face down these vexatious litigants, the problem is when they continue to appeal and appeal and appeal and appeal, and they're drawing out this case over time and draining your, litigation funds down the line, it's an important tool to have and know that, okay, at the end of this, or, you can do the appeal, or, whatever court you're in, whatever the process is. New York State is great. I think that, well, great-ish, maybe, great-ish, in the sense that, you can sort of have that. And where we've found it's effective is in a case where it's the beginning of someone's letter writing or they've filed a complaint, and you can see on its face that it's really just, it's not in accordance with the law, they're not going to win, it's just a grievance. It's not that something is false, it's that they didn't like it, right? So we've used it as a tool, in a letter, you can send a letter and say, hey, we saw you filed this, or you threatened to file this. Just a reminder that if we win, we also get fees. So you might want to think about your next steps. You might want to think about whether or not you're appealing this judgment, because at the end of the day, we're going to get that. So, that's more effective when you're dealing with someone who maybe doesn't have means or is an individual and they just have, a general grievance, versus when you're, looking at a more, wealthier individual or a company who, is not deterred by that kind of letter. So, again, tool in the toolbox in terms of just trying not to have the speech suppressed.
And then what about Section 230? So Section 230 provides a form of immunity from defamation claims for platforms that engage in some form of moderation of the content where they would otherwise be treated as a publisher, but they get treated not as a publisher, but just as a conduit for information that individual users put up. The individual users are subject to defamation lawsuits, but not the platforms themselves. So I assume for Vox and the New York Times, this is not immediately relevant because you guys aren't platforms, but it would very much shape your business model, how platforms are sending out information. And maybe comment sections are treated differently, I don't know. And then on the plaintiff side, I'm curious. I mean, it does seem like this is one of the greatest sources of filth in our media ecosystem is this nonsense that's put out every day on social media. And that seems like it'd be of immense importance to clients, how platforms are dealing with these problems. So I'm curious about that dimension of the problem, how you guys see 230 interacting with some of the issues we've been talking about so far.
So when I have a client come to me about social media posting that's inaccurate and defamatory, right? This is exactly the conversation we have, right? You can file a defamation claim against the judgment-proof person who posted it. You can't file a defamation claim against Twitter in the United States. So all of these big tech companies that have Section 230 immunity in the United States have also set up headquarters in Ireland in order to evade taxes. And in Ireland, you can get a court order to get problematic false content taken down. And so in those instances, I phone a friend, I have an Irish libel lawyer who we call, who is fabulous at getting this sort of stuff taken down. You can get an injunction in Irish courts to have false and defamatory content taken down if the Irish courts have jurisdiction over the platform, right? That's what's sort of key to this, is like, if Twitter was only here in the United States and hadn't set up headquarters in Ireland for tax purposes, this wouldn't work, right? But that's an option that's available. You may know this already, right? As a general matter, a US court is not going to order speech to happen or to be taken down, right? What you have here is an action for damages. This goes back to what I was saying earlier about globally, we in the United States are on the far end of the spectrum in terms of valuing free speech, and courts aren't going to compel speech or compel a platform to take something down. Ireland has drawn that line a little bit different, and that's an option that I make known to my clients. So you guys, I should bill you guys for that. I just gave you a tip, but if you need Peter's number, let me know and I'll connect you with him, so.
Well, as I recall, the platform sold 230 to Congress back in the, I guess it was 1990, it was the early 1990s, when the platforms were just beginning to develop, when we were just beginning to develop the social media system. And they sold the idea to Congress as a necessity for the successful development of this form of communication. They argued that it was so difficult to monitor the material that was being put out over their platforms that if they were treated like a publisher, like a Times v. Sullivan publisher, and even given the Times v. Sullivan protections, that it would be ruinously expensive for them to actually administer the Times v. Sullivan protections across a spectrum of 25 million posts in a day. And that it would essentially eliminate their ability to borrow money and to go to the markets. The markets would not fund an institution, a publishing institution, carrying that kind of liability anchor into the future. And Congress swallowed it and passed 230, essentially immunizing the emerging platforms from having to be responsible publishers, as long as they made some internal effort to do it. My sense is it is certainly time to rethink the economic question that was before Congress in 1990, and that is, without 230, would these platforms be able to flourish and be able to actually develop a new form of worldwide communication? And the fear was that unless the liability was lifted, we would stifle an extraordinarily important development in the ability to communicate. Well, we're now 50 years into that experiment, and they have been hugely economically successful. And there just isn't any question now that they are in an economic position to bear the costs of their own publishing decisions. And it's long past time to repeal 230 and to restore some form of deterrence to the kind of speech that goes on those platforms. Maybe we wouldn't want to replicate Times v. Sullivan exactly. We'd have to have a nice long conversation about what the liability rules should look like. But the idea of insulating those platforms from any responsibility strikes me as a terrible, terrible mistake.
I mean, I think, especially as that's a hard one to follow, so.
Yeah, try it, go ahead.
I'm gonna go after. But I would say, we were, a sort of like digital first publisher, right? And we also have New York Magazine, which is a print product, but also has a robust digital presence. So I would say it's not as cut and dry in the sense that, what we also, we have New York Times v. Sullivan, and then there's Section 230. We also have comment sections on our sites, and we also have user-generated content and forums and fan sites and all those things. So we do actually currently still benefit from that ecosystem, right? I think you really have to think about, if, cynicism aside, as far as, what the platforms, why they went to Congress and why they lobbied the way they did, right? If you sort of set that aside, it's kind of, was like noble, ideally, if you think about it, noble in its intent, in that, to foster communication and to allow for this idea, like you have to think back to the 1990s, like the promise of the internet, of this open exchange on the internet and communications and really opening up that world to people. I think that really resonated. But of course, now we're much farther along, and it anticipated this sort of like importance and function of moderators, right? So, and I think over time, that's really evolved to where I think what you're saying is, some of those arguments no longer hold up in the sense that, like, it's probably possible to moderate in a better way, and I think we've all been sort of lobbying for things, to make it safer for children and, all different ways. I think it might be incumbent upon us to sort of lean on these platforms to do a better job. I don't think I'm the right person to answer what the changes to 230 maybe should look like, if there should be any changes, right? But, that's really where I think the change is. And I would say, as a news publisher, right, who is doing all those things to, be within the New York Times v. Sullivan rubric, right, where we work really hard with the fact checking, and all of the stuff that, we were all just talking about. I'm often in the position of having to tell our reporters and editors, who are finding information, people are posting things on the internet. I have to have the difficult conversation with them to say, we are differently situated than that person who is posting the thing on the internet. Because while someone may feel a certain way about suing some individual who posted something that they don't like, they definitely will feel differently about suing an institutional media organization for that same speech. So, we're sort of doing the dance of, and especially I think this happened a lot during like the inception of the like Me Too stuff, which there was like almost on a daily basis, folks were posting on Instagram, this person was doing that, this person's doing that, and our reporters naturally wanted to follow those stories, and I had to have the difficult conversation and say like, well, they're maybe not going to sue that person who is the actual person who is alleging that the thing happened to, right? Versus the gravitas, I think, that's associated when you put something in print or when it's under the banner of the New York Times or it's under the banner of, New York Magazine is really different, and people feel a different way about it. So it's really set up this, like, I would say, like, there's like a dichotomy in the media ecosystem, right, where you have this sort of like social speech and you have, sort of institutional speech. And I don't think that I think they go together, but I think you just have to understand the difference in the landscape. I mean, you often hear, it drives me crazy when people jump up and down and they're like, free speech, because they're mad about something that happened on Facebook or they're mad about something that happened on Instagram. And I'm like, well, that's not really the First Amendment stuff that we're talking about. Like, that's actually, they're a private company and they can moderate and they can, do with their community guidelines. Like, it's a different rubric. So, there's a little bit of a course correction in perception of like what's possible and what the landscape is in both of those areas.
Yeah, and I take a slightly different view of the birth of 230. Burt is right that there was this belief that there was going to be this amazing garden of incredible information provided by citizens, and it was just going to be this wonderland of free expression, which rather than the cesspool it became. But what was driving it was two legal decisions that didn't make much sense that had been decided just before Section 230 was enacted. One was a platform, passed as a platform, then it was more of a bulletin board, but online, but it had moderated, it had taken steps to remove some things and leave other things up. It was found to be a publisher and have liability under the libel law. The other case involved the same sort of operation that did nothing, and it was found to have no liability. It was just like the telephone line, a telephone company. They provide the lines. What goes on there, you can't sue the telephone company if you happen to get defamed by two people talking on the phone. And so I think one of the questions that you have to look at legally is that if 230 goes away and those two cases still represent the law, you will have platforms that choose not to moderate, that choose not to take things down, that choose not to make any editorial decisions about the contents on there. And I think that is a bigger problem than shielding liability of the platforms who, I agree, have the money to defend themselves and are getting an incredible indirect federal subsidy as a result of Section 230. But I'd like to just tie back to the earlier discussion, which was that I think that Times versus Sullivan has worked brilliantly for institutional media, and I think that's a really good thing. I think it's great that it protects Vox and New York Magazine, the New York Times, Fox News, everybody, institutional media, because there are professional standards. There is fact-checking that goes on. There is an attempt to try to independently determine what the news is and provide that, and they should have, and those institutions should have protection. I'm not sure the same considerations apply online. I'm not sure that saying that the standard should be, as Times versus Sullivan says, did you know it was false? And sort of open the floodgates for people online who aren't doing anything other than airing untruths. Should they have the same protection that the New York Times has? Currently, that's the way it is. The Supreme Court's been very clear that the public's right to free expression is identical to the press's right. And maybe that calculation needs to be looked at. There is a movement afoot to look at the speech clause, and the press clause is different, and Burt's written about this brilliantly in other contexts. But, should in fact the Times versus, just throw this out, Times versus Sullivan be associated with the press clause, but some other standard apply to speech when it's somebody speaking in an individual capacity online?
So I invite folks to come up to the microphones and ask questions. While they're gathering, I'll just throw out one final question. Is there anything we should be looking at in the years ahead? Is there something, some burning issue that's sort of on the table?
Can I do a back to the future? Before Times v. Sullivan was decided, there was a huge discussion in the country about whether the libel laws should be changed. 3/4 of the country had adopted essentially a good faith standard, which is close to Times v. Sullivan, not exactly, and it was just the southern states that had not. So that there was a great discussion about what the libel laws should look like. And one of the interesting issues that came up was the question of a court of honor, the creation of a remedy that was not linked to damages. That money does not necessarily restore your reputation. It provides some compensation, but it doesn't really get to the heart of what the injury in a libel action is. And the court of honor was a place where you could get a determination of the truth or falsity of the charges against you. If necessary, the mandatory publication of corrective information. And so it was a vision of a non-monetary tort that would, I think, more closely fit with what and the beauty of it is that it didn't frighten publishers with ruinous liability. It frightened them with what should frighten them, and that's the loss of their reputation as legitimate sources of information. And so I wish we began to talk about courts of honor again as a potential way of thinking about how we go into the future.
It's not totally dissimilar to the British system, right? Which is that it's easier for a plaintiff to win a libel case in England. It's easier to get injunctive relief. And if you win your case, you're not going to get the kinds of big damages awards that you get here in the United States, right? So it's kind of a, it's a version of that.
It was inspired by the
here.
British system.
Yeah. Sorry, go ahead.
Thank you all so much for your time. A couple years ago, there was a defamation case against, I believe, Tucker Carlson, where the court found in his favor in part, arguing that the tone of his show was such that a reasonable audience member would know what he was saying was not supposed to be literally true.
Right.
And I'm curious, number one, what the origin of that distinction is, and number two, what you think its durability might be going forward, especially with so many people getting news online in formats that do kind of mix entertainment and information.
So as a general matter, rhetorical hyperbole and sort of pure opinion, that kind of stuff is not actionable, right? Because it's not understood to convey a false assertion of fact to the viewer, right? What I will say, I feel like I've had that Tucker Carlson case cited back to me a million times, because when we sued Fox News on behalf of Dominion Voting Systems, one of the shows at issue was a Tucker Carlson show where after January 6th had happened and after all of the information had been provided to Fox News proving that this was nonsense, Tucker decided to have on his biggest sponsor, the MyPillow guy, to come on and again repeat the lie that the voting machines had rigged the election. And so I'm familiar with that case. So what I would say is it's not it's not as broad as nobody would take anything that Tucker Carlson says seriously, therefore he gets a free pass to say whatever he wants, right? What gets analyzed is the particular broadcast itself, and does this particular broadcast convey a false assertion of fact? Would people understand this to be an assertion of fact? And so it really isn't, it's not that some people are so ridiculous that anything they say is going to be immune from defamation liability. It really has to be analyzed within the confine of the particular broadcast that is being sued over.
In my nefarious past, I played Jerry Falwell in The People versus Larry Flint, the movie that was about, and the movie was about a libel prosecution where Falwell sued Hustler magazine for running a cartoon saying that Falwell had had sex with his mother in the outhouse behind their home. And this was a Hustler cartoon, and Falwell sued for both libel and emotional distress, and won a huge jury verdict below. And the Supreme Court, in a very important case, threw the verdict out on the grounds that satire has to be protected. I mean, if you took the literal truth of a statement and made it the foundation for a libel action, it would eliminate subtlety. It would eliminate all sorts of very important communication. So I think the Carlson case was right. And I think the protection of satire and hyperbole is very, very important.
Yeah.
And by the way, go to see the movie, because
Wait, so you were really in the movie? I'm so excited.
it's Milos Forman. He cast me.
Yeah.
And I get a royalty each time you go out and look at it. So please, fund my retirement.
Put the link in the comments in the video.
Right. No. I mean, I think something that's surprising for people is that really defamation law is on a statement-by-statement basis, right? And so, you have to, a false and defamatory statement, in fact, of and concerning a person, but the first prong, a false and defamatory statement of fact, right? And so in that sense, context matters, and it's a statement-by-statement thing. So, another example of this is like the very cut and dry example is like something that's in an op-ed box, right? Like an editorial box. Audiences will understand that what's going to be included in that box is opinion. So I think that's really the argument, that's sort of made, is that when viewers turn in, they understand for the most part that these talking heads are going to be spouting their opinion. But then where it gets tricky is that there are statements of fact within the construct of that opinion rubric. So, when you drill down statement by statement, it has to be like, do people understand this particular statement is an opinion, or this particular statement is fact? So that's hard. And I do think that it's increasingly difficult to discern in our current landscape. But the court got it right.
Hi, everyone. Ooh, sorry. Thank you so much for being here. Okay, I might just hold this. I'm Maria. I'm a 1L. Thank you again for being here. As a 1L, I'm kind of just still figuring everything out. So I wanted to know, how did you all know that this was what you wanted to do, and how do you recommend people start getting involved? Thank you.
I mean, it was just sort of random, honestly. I had an enormous amount of student loans, so I went to Kirkland & Ellis. Great law firm, loved it there, but I was just doing commercial litigation. I did a little bit of defamation stuff for corporate clients there, and it was a lot more interesting than other commercial litigation to me. So I focused more and more on it, and then left Kirkland to start a plaintiff side defamation boutique.
Well, I mean, I think you can't know. You can't know now at your stage what's really going to make you happy. I went to law school to be a labor lawyer and to work for the union movement. But in my years, those were the Jimmy Hoffa years. Those were the years where the unions were extraordinarily, or appeared to be, extraordinarily corrupt and extraordinarily obstructionist in terms of blacks and women being able to move forward in the economy. And I couldn't see myself devoting myself to the labor unions. So I did the next logical thing and became an estate tax lawyer. And I went to Wall Street, and I spent 3 years on Wall Street planning the estates of extremely rich people so that they didn't have to pay any taxes, for which I'm still going to do many years in purgatory. And then in 1967, I went over to the New York Civil Liberties Union on a one-year leave of absence to defend demonstrators against the Vietnam War, and I never went back. And it took a long time for me to know what I wanted to do. And one of the things I urge you to do is have the courage to experiment. Don't think you have to know now, and don't think you have to lock yourself in to a career pattern that you just don't know yet what makes you happy. And the beauty of the law is that you can move in lots of different ways and take advantage of it.
Absolutely. I mean, that's just amazing advice. I would urge all of you to listen very carefully to that. I mean, I took a very non-traditional path, so I think it's, I worked in film and television production. I thought that's what I wanted to do forever. And then I got there and was like, oh God, no. And then I thought, well, I'm going to be an entertainment lawyer. And I did that for some minutes and then realized that that really wasn't it. And I had to I did some in-house things. I mean, I did lots of different things, and I sort of honed in on this thing when I got a job at HarperCollins Publishers, and I learned how to vet books and all of these things from some amazing colleagues, and I really was able to hone in on this thing, this like through line of all of my interests, which was really passion for freedom of expression. And that has been the driving force. And like I said at the beginning, I didn't even know that the job that I have was a job that people had. So I didn't go to big law. I didn't work in big law. I worked in boutique firms, and I just sort of, took different chess opportunities on the board to land where I landed, and happily so. But I'm also still trying to figure out what I want to do when I grow up. So, it never
Meier
ends.
Watkins.
It never ends.
And my story will be of illuminating to virtually no one in the room. I didn't go to law school till I was 34. I was a college professor. I was teaching journalism. And essentially my college sent me to law school because they wanted to broaden their journalism offerings and have something about the law in there. I always took great comfort when I was a 1L, Maria, because when it was really bad, I would say, all these people chose this, and I was sent. It's not my fault. And then I worked as, I clerked, I worked as in straightforward sort of commercial litigation. And then through the law firm I was out, I became aware there was an opening at the New York Daily News for an in-house lawyer. And I sort of looked the part. I had taught journalism. I'd been a journalist. I knew a little bit about commercial law. They wanted to have somebody who could do both media law and commercial law. And the lead legal person, the chief legal officer of the company, the Daily News in those days, admitted that he was looking for a veteran. He was looking for a veteran. I'm not a veteran. I am the son of two veterans. That's close, but not the same thing. But I was old for being an associate, and that was just almost as good as being a veteran, I guess.
All right, well, we're at time, so join me in thanking our wonderful panelists.